Hi, good morning, good afternoon, and good evening. Welcome to all those who are joining us, depending where you're joining us, what part of the world you're joining us from. My name is Katia Al-Khatib, and I'm a Senior Research Officer for the Human Rights Center. I'm happy to introduce this session today. It's part of the Human Rights Center speaker series. We have with us Professor Kristin Henrard, who's going to talk about state obligations to counter Islamophobia. And we have Dr. Aoife Duffy, who will be chairing this session. I'll pass the floor to you, Aoife, and I'll see you at the end.
Okay, thank you, Katja. I'd like to take the opportunity to introduce Professor Kristin Henrard to everyone here. Kristin is a professor of international law at the Institute of European Studies and Vesalius College. She has a substantial volume of publications, many of which pertain to human rights and minorities, ranging from educational rights, linguistic rights, the prohibition of racial discrimination, socio-economic rights, political participation, and religious fundamental rights. Several of Professor Henrard's publications elaborate on the role and legitimacy of international courts. She continuously expands her multidisciplinary scholarship into such areas as integration and citizenship. The format for today will be a 45-minute presentation followed by questions and answers. So without further ado, I would like to welcome Professor Henrard to Essex Human Rights Centre virtually, and I will now hand over for her presentation.
Thank you very much. It's my pleasure to take part in this lecture series. I hope someone else is going to, so we have a little bit of an issue because I wasn't able to share my screen with the PowerPoint. Someone is organizing it for me. And that will happen soon, I gather. Yes, absolutely. So basically, as you already heard, and as you saw in the presentation, we're going to focus today on Islamophobia and state obligations to counter Islamophobia while comparing fault lines in the quasi-jurisprudence of some supervisory mechanisms. So what am I going to do in the introduction? I'll offer some reflections on Islamophobia and also the frame of analysis that I will use throughout the presentation. Subsequently, we'll have a closer look at the type of supervisory practice that these three international courts produce, because that also determines the way in which the analysis will proceed. And then I'll go into the analysis of this quasi-jurisprudence of these three international courts, first one by one, the Human Rights Committee, then the European Court of Human Rights, and as thirdly, the Advisory Committee of the Framework Convention for the Protection of National Minorities. To, in a second step of the analysis, compare the fault lines between the jurisprudence, quasi-jurisprudence of these three international courts, ending up with some recommendations towards for development of that quasi-jurisprudence. Exactly. So turning to the introduction, it's very hard to miss that there have been rising levels of Islamophobia in the West, and more particularly since all kinds of terrorist attacks, starting with 9/11 and even before that, but that really triggered this growing Islamophobia in the Western world. Talking about Islamophobia, it's quite striking, and there are several volumes of literature on that concept, on Islamophobia, but there's no generally agreed upon definition of Islamophobia yet. And nevertheless, in its core, it's clear that Islamophobia concerns intolerant attitudes, prejudice against Muslims, ultimately policies and practices targeting Muslims. So very fundamentally, Islamophobia is intrinsically related to discrimination against Muslims. Here, it's already immediately important to flag the fact that discrimination against Muslims is never only just discrimination on the basis of religion, also to do with the fact that Muslims are not only defined in terms of their religion, but also in terms of their assumed ethnicity. And this also has to do with the fact that the dividing line between ethnic and religious components of group identity is never really crystal clear, is never really very sharp. In this regard, Islamophobia has also been called a particular kind of racism targeting Muslims. And so clearly acknowledging this intersection between race and religion that is basically inherent in Islamophobia. Coming to that, so it's actually the intersectional discrimination inherent in Islamophobia is often also is intersecting with gender, and that then concerns especially all kinds of measures that block the wearing of religious garments, which disproportionately target or affect women, Muslim women. And thus you have this intersection of three grounds happening in relation to Islamophobia. Now, in addition to the angle of discrimination, Islamophobia and acts inspired by Islamophobia also lead to a disproportionate, arbitrary limitation of several fundamental rights. And if we look a bit further in the broad range of manifestations of Islamophobia, we can identify these other fundamental rights that are relevant. Obviously, Islamophobic measures can take the form of disproportionate limitations to manifest one's religion. I think about all disproportionate limitations about wearing religious garments, obtaining religious slaughtered foods, etc. So there can be, these type of measures can be infused by Islamophobia, so triggering a potential violation of the freedom to manifest religion. More forms of discriminatory violence against Muslims, that could then trigger potentially the prohibition of torture, inhuman and degrading treatment as well. Whereas Islamophobic or measures inspired by Islamophobia could also lead to a disproportionate limitation of access to education, employment, public space. So there's this interaction between discriminatory elements and also limitations to a range of fundamental rights. Yes. Continuing with, the link of the frame of analysis, linking this with human rights. And the body of the doctrines of human rights in general is fundamentally concerned with the effective protection of these fundamental rights. And here it is important that the state obligations are not only negative in the sense of limiting particular arbitrary limitations of human rights by states. It's not only negative state obligations, also positive obligations aimed at the effective protection of fundamental rights. And over time, also the jurisprudence of the European Court of Human Rights is very good in elaborating that by emphasizing that rights need to be real and effective, not theoretical and illusory. The court has continuously identified an expanding range of positive state obligations. Thinking in terms of state obligations and countering Islamophobia, countering intolerance, it's important to also realize the symbolic power of public policies at the extent to which legislation can be potentially stigmatizing. And here you could, first of all, think of legislation which directly discriminates against Muslims, but also measures legislation that indirectly discriminate. And then you can think about legislation in neutral terms, but with a disproportionate impact on Muslims, and especially when that is in a context of Islamophobia, the stigmatizing effects thereof are not to be discounted. In that respect, when you want to counter intolerance, it's not only important for states not to engage in what we call stigmatizing legislation, but also to go a step further and undertake actions to really counter intolerance, which is inherent in Islamophobia. Yes. So as it was already visible in the previous overview of relevant fundamental rights, these are predominantly in terms of general rights, the freedom of religion and the prohibition of discrimination. That will be the main focus of the analysis. But as Islamophobia targets Muslims as a particular religious and ethnic minority, minority-specific rights are also relevant. So these are also going to be taken on board in the analysis. And then, of course, a further focus, because there's a limited amount of time that I can speak today. I focused on 3 international courts, and I see it's dropping a little bit of the visuals, but I will say a little bit in a second about the concept of international court. So it's the Human Rights Committee of the ICCPR, the European Court of Human Rights, and the Advisory Committee of the Framework Convention. So about these 3 international courts. First of all, the concept international court. This is used in a broad way, in the sense of bodies that are mandated to supervise the implementation of states' obligations in relation to a particular human rights convention. And so it's not only the courts in the strict sense of the word that have the power to pronounce legally binding judgments. That's actually only the European Court of Human Rights. But also the Human Rights Committee, who pronounces non-legally binding views. And in this respect, I just want to make a little note that it's increasingly accepted that the difference between legally binding judgments on the one hand and not legally binding views is not as big as it seems in the first place, because in the end, it's always about persuading states to comply. Even legally binding judgments, that states cannot be forced to comply with them, whereas there can be a lot of pressure, actual de facto pressure on states to comply with not legally binding judgments. So in that respect, the difference is less than it may seem at first sight. There is something that I do want to highlight: the difference when the supervisory practice of these international courts, in the broad sense of the word, is focused on individual complaints, or rather consists of what we call periodic state reporting, in the sense that when, for example, the European Court of Human Rights and also the Human Rights Committee, when they are dealing with individual complaints, that on the one hand, yes, please continue. About individual, yes, that has the benefit of that the outcome of these procedures have a potential direct impact on individual claimants. On the other hand, it also means that when you as a court depend on individual claimants coming to you, that the amount of jurisprudence that you can develop is also dependent on what type of cases are coming to you. On the other hand, if you look at the periodic reporting, indeed, that seems to have the disadvantage that you don't have potentially, the outcome thereof doesn't have a direct effect on particular claimants. However, the benefit of periodic state reporting is that it happens on the basis of these state reports, complemented by shadow reports by NGOs, and that it's basically dealing with the full picture. So that you, as a supervisory mechanism, you have overview over the full length, the full scope of potential implementation measures. So you can develop a more extensive jurisprudence in that respect, because indeed, even if it's not in terms of individual complaints, the pronouncements that are made in regard to these periodic state reporting, also there you can develop particular jurisprudential lines that are then captured often in terms of periodic thematic commentaries that kind of synthesize the lines of jurisprudence that come out. So in that respect, I wanted to give you a little bit more insight into what the different supervisory practices is that we are taking into account, and how they, what are the benefits of the respective supervisory mechanisms. Okay, let's now turn to the actual, yes, oh, sorry, one last point, very important one. So what am I looking at? As I said, it's a different type of supervisory practice that I'm taking on board when I compare these 3 international courts. Nevertheless, I've been looking at items that were recurring in these, that were relevant from the standpoint of Islamophobia. and that were coming back in these three, the supervisory practice of the three international courts. So for each international court, I will be looking at questions of more latent forms of discrimination, and so neutral measures with disproportionate impact on a particular group. Also questions of discriminatory violence. And thirdly, also dropping off the line, questions of education. And I'll be expanding on that while I'm going through the supervisory practice of the three courts. Yes. So let's zoom in on the supervisory practice of the Human Rights Committee. Now, actually, if this is the point that I tried to raise already earlier, when you look at the complaints procedures of the Human Rights Committee, these are not that extensive, and especially not when you just zoom in on questions of prohibition of discrimination, freedom of religion, and Article 27, which concerns minority-specific rights. And especially when you look at those pronouncements that are directly related to Islamophobia. Nevertheless, what you can do, and what I have done, is looking at the jurisprudence in relation to these rights of relevance to religious minorities more generally, because you can then also consider what kind of repercussions that would have in relation to Islamophobia as well. So, starting with Article 8, the freedom of religion, and Article 27, as I said, there is not that much in terms of religious minorities, but there's one that I want to highlight at this moment, and that is the Waldman. As I said, it's important to look at the baseline of the jurisprudence of the Human Rights Committee. And so there's one case that I want to highlight here, and that is not in relation to Muslims, it's in relation to a Jewish father, Waldman versus Canada. And it's a complaint about the fact that in Canada, private Jewish schools are not funded, whereas private Catholic schools are funded. And he invoked both the freedom of religion, the prohibition of discrimination, and the minority rights provision. And what you see happening is that the Human Rights Committee establishes a violation of the prohibition of discrimination by saying, well, you know, a state isn't obliged to provide funding for private schools, but if it does, it needs to do so in a non-discriminatory fashion. And the court, or the Human Rights Committee, doesn't think that the justification of Canada is satisfactory, so it concludes to a violation of the prohibition of discrimination. And so there was a critical assessment, a critical review of the pronouncement of the justification of the state. So what you see is, that's already too fast, but it's okay. So what you see here is that the Human Rights Committee chooses to give central importance to the prohibition of discrimination in relation to matters concerning religious minorities. And it really focuses on that. It establishes, reaffirms the importance of the right to equal treatment in this regard. And it scrutinizes strictly. So that is important in this regard. Looking at the freedom of religion jurisprudence, there is a lot actually that focuses on negative state obligations and not so much the positive state obligations. Nevertheless, also here, it's relevant to take into consideration, because what you see happening here is, again, a very strict baseline scrutiny, in the sense that there's an in concreto analysis of a potential threat invoked by the state. The Human Rights Committee is very critical about, you know, the legitimate aim that is being invoked, whether it's appropriate, and also very critical about questions of proportionality. And so is the limitation then proportionate to the invoked legitimate aim? To give you a few examples, there's a French prohibition to wear religious headgear, which affected also a Sikh who wanted to wear a turban. And there the Human Rights Committee says, you know, okay, it is indeed legitimate that you would want pictures on an identity card to be representative, but that in case of a Sikh wouldn't actually mean that he can wear his turban, because it doesn't cover his face and he always wears a turban, so it's quite representative. So you see an intense scrutiny of the limitation imposed by the state. And so that, and you see that in other cases as well. So that is quite, this very high baseline scrutiny is something to highlight. Then let's go to cases that are more, next slide, please. Yes, that are these questions of latent Islamophobia. So these are really cases that you can put in directly in the frame of the Islamophobia cases, and more particularly cases that concern prohibitions on the wearing of headscarves and burqa, some of which concern the effective access or limit the effective access to the public space, others effective access to employment. So let's have a closer look at that. Yes, so these two, Hebaj versus France and Yeker versus France, these concern the French, both concern the French prohibition, criminal prohibition of wearing garments that conceal the face in public, in the public space at large, right? And these two women complain about violations of the freedom of religion and the prohibition of discrimination. And what you see in both is that the Human Rights Committee establishes a violation of both the freedom of religion and the prohibition of discrimination, each time adopting really strict scrutiny. And so, for example, in relation to the freedom of religion, it says about the argument in terms of public order. Okay, public order, that is a valid, that is a legitimate aim, but public order is not something that plays, that would allow for a general ban on the face covering veil. It would be too far, so that is discarded. Another aim that had been invoked was the living together. Living together had been put forward by France as an argument, as a legitimate aim that would be encompassed by the rights and freedoms of others. And here the Human Rights Committee says, no way. They just didn't accept that living together would be a legitimate aim that could support the limitation. So clear violation of the freedom of religion. And also in terms of the prohibition of discrimination, similarly, the committee establishes a disproportionate impact on Muslim women of this rule without proper justification from France or so. And the committee says, strictly analyzing what France was coming up with. And actually, it even goes a step further and says, you know, the exceptions in that French law are so many that in the end, the law only seems to affect Muslim women. So basically hinting at the fact that it may even be a case of direct discrimination. So the Human Rights Committee is extremely strict. Keep this in mind, because we're going to see a similar case before the European Court of Human Rights, which was decided completely differently. And so, okay, that was a second category. So we started with the baseline case, baseline level of scrutiny of the Human Rights Committee. Then we looked at some cases dealing with latent Islamophobia. And now I want to go to the last set of, sorry, that is still that, the latent Islamophobia in relation to employment. FA versus France concerned the dismissal of an employee in a child center because she was wearing the headscarf that had been imposed by internal regulations supporting secularism and neutrality in France again. So according to the center that outweighed the freedom of religion of that employee. Also here, the committee is very strict in its scrutiny, and it establishes a violation of the freedom of religion because it says, you know, where is the legitimate aim here of the limitation? Because wearing a headscarf can in no way be considered to be proselytizing. So again, really strict scrutiny in concreto of what the state had been invoked as the legitimate aim of the limitation. Furthermore, the committee even highlights, you know, such a legislation and the way it affects Muslim women actually has a stigmatizing effect on this religious community. So the Human Rights Committee is spot on in emphasizing the negative impact on the group, on the religious minority group concerned in terms of integration and actual participation in society. Secondly, in terms of the discrimination, the complaint, the committee establishes intersectional discrimination on grounds of religion and gender. So because it and noted the disproportionate impact of this neutral rule on Muslim women without sufficient justification. So again, you see a very strong analysis, high baseline level of scrutiny, which leads to establishing violations by France. Exactly. Yes, so that brings me to the third component that I was looking at in relation to the Human Rights Committee, and that's the educational question. And of course, here it's important to keep in mind that education is indeed a very important, not only important in terms of qualification, but also important in terms of socialization. It's about transferring the values in society, and that could also does have a positive effect if you want to create a society which is tolerant towards the different groups. And that triggers then questions about, okay, what does this mean in terms of the public curriculum and state duties in this respect? Yes. When you look at civil and political rights, as is the case for the ICCPR, what you see there in terms of education and the content of the curriculum is a state duty to respect the religious and philosophical convictions of parents. Now, yes, go on. So you don't see anything about, it's not explicitly about the need for an inclusive curriculum. It doesn't explicitly demand questions about, that there needs to be the creation of, there should be an emphasis on tolerance. Yes, go on. But there's still a strong protection against indoctrination. Public education needs to be objective. And here there has been, it's a case that doesn't concern Islam as such, but it is an important case because it shows the baseline attitude of the Human Rights Committee in this respect. There was a case that concerned a course on religions, supposedly in Norway. And the complaint was that this was actually not a neutral course on religions, but a course that focused completely on Christianity. And what you see happening is that the Human Rights Committee has a very critical assessment of the content the content of the allegedly neutral course, and basically emphasizes that it's everything but a neutral course, and then also is very critical about the exemption scheme that was allowed and which was very restrictive. So again, you may say, okay, it's not explicitly in terms of Islamophobia, but it does show that the jurisprudence that has been developed by the Human Rights Committee would be capable of possibly preventing latent forms of Islamophobia to creep into the public curriculum, considering the very strict review that it's doing. I said to some extent, this is an extrapolation of the jurisprudence that is there. So overall, going to the last slide on the Human Rights Committee, what we see happening in this regard is that the Human Rights Committee has a very strong baseline of protection, always very in concreto critical analysis of a particular limitation and the state justification thereof. And what you see happening is that when that is the case, this strong baseline of protection, there seems to be a proper protection against Islamophobia, which we saw explicitly in these three cases on latent discrimination, and for the others it was more implicitly deduced from other jurisprudence. So even when there's no explicit focus and acknowledgement of an Islamophobic context, if the baseline of protection is strong, there's a proper protection against Islamophobia offered. So that was what came out of the Human Rights Committee. So let's, oops, something went wrong with the share screen. And there we are again. Hi, this happens, that's online for you, right? So let's go to the European Court of Human Rights, the ECtHR. Exactly. So as you all know, the ECtHR is a very highly respected international court that jurisprudence often serves as inspiration for other, both international and national courts. At the same time, there's also some critical literature on particular lines of jurisprudence, and this is certainly also the case in relation to the two rights that we're focusing on here, namely the freedom of religion and the prohibition of discrimination. So also here, I'm going to go in 3 steps. First, looking at baseline of protections, then looking at cases of latent discrimination, and then looking at curriculum educational questions. So looking at the baseline of protection that the European Court of Human Rights offers in terms of the freedom of religion, let's start with positive things. There are very promising features in the jurisprudence that seem to speak for a strong emphasis on state obligations to counter intolerance. Why? Because the committee emphasizes, looking at the freedom of religion, that would require states to be neutral organizers of religions in their territory. They should protect and promote religious pluralism and mutual tolerance. And so that seems to speak completely in favor of countering intolerance against particular religious groups. Similarly, the court has a steady line of jurisprudence that if there are tensions between religions, the state shouldn't choose sides. No, the state should promote religious harmony. So that seems very promising. At the same time, the court tends to give a broad margin of appreciation to states in regard to positive state obligations that are having in regard to the broad category of cases that fall under church-state relations, broad margin of appreciation, and also in relation to controversial matters, which is often the case when it's about regulations of the manifestation of Muslim religion. So yes, there are positive features, and at the same time, there is the broad margin of appreciation that tends to limit the actual protection impact of the jurisprudence of the European Court of Human Rights in this regard. Let's turn to the prohibition of discrimination. There, it's been said for a long time that the jurisprudence of the court in regard to discrimination was a Cinderella, very not very well developed. The court used to avoid it as much as possible, this analysis, and if it did entertain the analysis, it was very light in its scrutiny, so not offering a lot of protection. Next slide, yes. But in regard to the prohibition of discrimination, there have been several developments, and more particularly identifying so-called suspect grounds that would lead to heightened scrutiny. However, the problem here in regard to what we're looking at is that religion as a ground of differentiation has never been acknowledged to be suspect in relation to Article 14 and 9 by the court. So somehow the court refrains from explicitly acknowledging that religion is a suspect ground of differentiation, which doesn't mean that the court wouldn't give proper protection against discriminatory violence. So it's not acknowledging religion as a suspect ground has the danger that there may not be sufficient protection against religious discrimination. What we do see is when it concerns discriminatory violence, the court has a line of jurisprudence that tends to be rather high, or that tends to provide high protection. This is particularly visible in relation to Jehovah's Witnesses. However, there has been one case which concerns Muslims, so discriminatory violence against Muslims, where the court was less forthcoming. More particularly, it was a case, Karamet versus Bulgaria, that concerned a violent disruption of the Friday prayers at a mosque. So there was violence involved. And more particularly, there was a political party involved that was very anti-Islam. And what we saw happening, well, the court did establish a violation of Article 9, but it avoided, again, the non-discrimination analysis, whereas this would have been an obvious avenue to take, knowing that the political party was an anti-Islam political party. So that's a bit dodgy in that respect. Furthermore, last qualification in regard to the prohibition of discrimination is that the court is still rather reticent in engaging in a non-discrimination analysis when it concerns expression of identity issues, controversial issues again. Okay, let's go on. So then go to the second block of cases of the European Court of Human Rights, the question of latent discrimination, and that is the most strikingly the case, latent discrimination, Islamophobia in terms of Islamophobia, sorry. And the case here is SAS versus France. This is an equivalent case to the Hedbaj and the Yaker case against France that we discussed already in relation to the Human Rights Committee. SAS versus France is the first case that the European Court had to deal with this French legislation prohibiting garments, religious garments that cover the face in public. And what you see there happening, it's quite disconcerting. It starts promising to some extent, in the sense that the court notes with concern that there were Islamophobic remarks during the making of that law, and that is at issue in the case. And the court even emphasizes that this risks encouraging intolerance and stereotypes, etc. So there seems to be, the court seems to say, okay, we will really need to scrutinize this strictly. So that's what the impression that the court was giving while it was looking at questions of the legitimate aim. However, go on. What we then see happening is that the court, when it proceeds in its analysis, everything but engages in a heightened scrutiny of the limitation concerned. And more particularly, what you see happening here is that the court accepts the arguments of France, which was not accepted by the Human Rights Committee. The court accepts that the requirements of living together would fit under the legitimate aim, the rights and freedoms of others. So they accept that as a legitimate aim. I cannot emphasize enough how problematic that is. You have to think about who are these others? What are the rights of others that would be invoked to limit the freedom to manifest one's religion by the Muslim group, by these people that want to wear that? So who are these others? These others are the majority, the French majority. And so basically what the court, when it uses this argument in terms of legitimate aim, it's engaging in what is called majoritarian reasoning, whereas the whole human rights paradigm has an anti-majoritarian, counter-majoritarian, shall I say, counter-majoritarian core. So this type of reasoning is most problematic because it basically puts the whole human rights paradigm on its head. Especially so because when the court goes on to provide or to grant states a broad margin of appreciation because there's no European consensus, and this was a question which was inherent, a question of society. Society has to decide for itself. And so the amount of protection was limited. Going on to the next point, the discrimination analysis, there was no distinct discrimination analysis. The court says, well, yes, that it may be disproportionately affecting women that for religious reasons want to cover their face. But because of the reasons we gave before, there's no discrimination. So there was no separate discrimination analysis, just for whatever we said before, there's also no discrimination. And so that is a very limited analysis. So what you see basically happening is that in a situation where the court itself has noted that there was an Islamophobic context in which the legislation was adopted and in which the legislation was implemented as well, the court still doesn't adopt a very high level of scrutiny, engages in majoritarian reasoning, and thus allows states to be intolerant and to be assimilationist in their approach. Can I go to the next slide? Yeah, states are allowed to be intolerant, exactly. So then the last section concerns education, and that is a case Osmanoglu and Kosabas versus Switzerland concerning Muslims. Here I first want to make a note in terms of the development of the jurisprudence in this regard of the ECtHR in regard to curriculum questions. Folgerov versus Norway is quite similar to the Lervach case that we had seen by the Human Rights Committee, and also the European Court of Human Rights in Folgerov has made an important step in terms in the way in which it analyzes the state duty to respect religious convictions of parents in the public curriculum. in the sense that it also, because it was the same factual situation, the same case, the same course that was problematized in Folgero versus Norway. Also here in Folgero, a very critical analysis of that particular course that wasn't a neutral course, but very much focused on Christianity, and also very critical about the exemption scheme. So, you know, it seemed to convey to the world at large, the European Court of Human Rights is going to scrutinize this obligation of states rather strictly. And there's also basically allowing parents to invoke religious exemptions to particular parts of the public curriculum in certain circumstances in the event. Let's go to what happened in Osmanoglu and Koshabas versus Switzerland. This was a case brought by parents, Muslim parents, that wanted their girls to be exempted from the mixed swimming class in a public school in Switzerland. And Switzerland didn't allow that. They had a very limited amount of exemptions that were allowed for this public swimming, and religion wasn't one of them. So there was a whole conflict, so they had to pay a fine, and the parents went eventually to the European Court of Human Rights. Yes, exactly. Yes, I said that already. What you see happening in the jurisprudence of the European Court of Human Rights is that it actually doesn't engage really with the claim of the parents that this the problematic exemption scheme basically entails a violation of the freedom of religion. A quick note here, why is this in terms of Article 9 and not the Education Article 2 Protocol 1? Because Switzerland hadn't ratified Article 2 Protocol 1. So this issue comes in via Article 9, but the court interprets it in light of its jurisprudence in terms of education. But okay, so the baseline is no serious engagement with the claim of the parents. And this is again the first problematic note to be made. What happens is that the court again easily accepts the argument of Switzerland about the fact that, you know, the obligatory mixed swimming is aimed at the social integration of foreign children from different cultures. And this would then again fit under the legitimate aim, rights and freedoms of others that needed to be respected. Again, these others can be nothing else but society at large that wants to get a grip of is keen on integrated society and wants to push minorities in the fold. So again, this type of reasoning, with accepting this type of reasoning, the court engages in majoritarian reasoning and linking or accepting that type of argument by the states. If you look at the context, at first sight, it may be not as problematic as the SAS versus France case. Here, there are no signs of Islamophobic remarks in the legislative process. However, if you look a bit closer, what was clear is that one of the highest courts in Switzerland, when it was dealing with this case, actually emphasized that this goal of social integration was particularly important for the Muslims because they had been growing so fast recently in terms of numbers. So somehow the Muslims are still presented as a potential threat to the national society, especially when their numbers would be growing. And so there is still in the reasoning of the highest court of, of Switzerland, there is something that hints at some prejudice in any event against the Muslim group. And again, following this reasoning, legitimate aim accepted, broad margin of appreciation again because it concerned the curriculum, etc. So again, no violation. So basically, again, the court allows states to be intolerant towards as assimilationist, if you want, towards the Muslim group. Thank you. It's going to wrapping up the evaluation of the European Court of human rights jurisprudence. So what we see happening is that the European Court doesn't guide states toward tolerance, but rather confirms intolerant Islamophobic policies by states, and thus allowing the majority to be intolerant assimilationist. Yes, go on. And in terms of non-discrimination, it's quite striking that even in contexts that are blatantly Islamophobic, the non-discrimination, separate non-discrimination analysis is avoided. There's no time to go into these other cases, but that just also confirmed that the court avoids the discrimination analysis. So in the end, what you see happening is that overall conclusion that when the court, like European Court of Human Rights, doesn't have a strong baseline protection, it becomes extremely important to mark an Islamophobic context that could potentially justify higher scrutiny. Yes, thank you. And let's then go to the next slide. And the third court, the advisory committee of the Framework Convention regarding for the protection of national minorities. I'll say something about the text, then I'll look at the interpretation, and I'll be zooming in on particular articles concerning equality, freedom of religion, and integration in this respect. So it's slightly structured differently because there's no cases to focus on, but the same themes will be touched upon. So let's have a look at the preamble of the Framework Convention. So it's very strongly emphasized that, it's important, minority rights are important for peace and stability in Europe. And so a climate of tolerance and dialogue needs to be created by states. And so a very important emphasis is on the effective protection of the fundamental rights of minorities and their inclusion in society. If you would, the Framework Convention would, if you would say what would be the central pillars, you would find them in Article 4, 5, and 6, focusing respectively on the right to equality, equal treatment, identities, Article 5, Article 6 concerns tolerance, so these the state's duties to counter intolerance and promote dialogue. That would be Article 6. So, in addition, when you would focus on, okay, state duties to counter intolerance, where would you find that? Of course, as I said already explicitly, it's focused upon as such. It's a really strong focus of Article 6, as this whole idea of promoting knowledge and cultural and intercultural understanding. It's all about dialogue and tolerance. That's the whole, and thus integrating the groups in society. So very clearly visible there. And Article 6 already refers to education as a very important method to achieve that. So Article 12 on education and the curriculum, also there's a strong emphasis on, fostering knowledge of each other's culture, religion, history, and thus creating a tolerant society in which there's a lot of dialogue and, interaction. Basically, so facilitating contact between the groups. Thank you. Next slide. So what about interpretation? So you would expect a lot of attention for state duties to counter intolerance and Islamophobia more specifically. Now, go on to the next one, where so the articles we're looking at is 6 and 12, obviously, for equality, and Article 8 dealing with the freedom of religion. Now, we see a very elaborate concern, very elaborate lines of jurisprudence concerning attention for Islamophobia and the need to counter Islamophobia in regard to Article 6, the tolerance article, so they say, and Article 8 on the freedom of religion. And so there, the advisory committee emphasizes that all kinds of limitations, many limitations on the manifestation of religion. Often there are all kinds of stereotypes at play that leads to, and it problematizes the extent to which it actually limits the participation of the groups in society at large. And so it also inhibits their access to jobs, their broader socio-economic participation, and thus their broader participation in society. And so in that respect, the committee also notes that, as a state, you have to be really vigilant about particular public discourse to the extent that public discourse might fuel Islamophobia, and you should counter that. So very explicit obligations in that respect. And so the states have to make active efforts to improve the dialogue between Muslims and non-Muslims and to fight intolerance. So very, very strong in that respect. However, next slide. If you would expect similar focus in regard to Article 4 on equality, right, the non-discrimination provision, and Article 12 dealing with education, whereas education was mentioned specifically as having a very important role in creating a tolerant society. And some way, one way or the other, there is no focus, no strong focus on Islamophobia and duties to counter Islamophobia. In that regard. Next slide. So that brings me to saying that in this regard, in terms of the Framework Convention for the Protection of National Minorities, there are several positive baselines in the supervisory practice that counter intolerance, so state duties to counter intolerance between groups, also between religious groups, but it is not consistently used in regard to Islamophobia. So a lot more is possible. Next point, yes. So in what is a quite red line in the jurisprudence also of the Framework Convention is its importance for fundamental rights to be effective. And obviously questions of fighting intolerance is important in terms of providing or enabling the effective enjoyment of fundamental rights. That's an easy step to make. The steady lines concerning the positive value that needs to be attached to diversity and an inclusive society similarly leave a lot of scope to identify these obligations to counter intolerance, counter Islamophobia. Also in relation to Article 4. If you really zoom into jurisprudence of Article 4, the right to equal treatment, there's a lot of attention for, there needs to be good legislative framework, there needs to be proper enforcement, there need to be awareness campaigns about, the positive role of minorities in society, etc., all meant to counter discrimination. So there is quite a vast body of jurisprudential lines in this respect. It's very well developed in relation to Roma, but so far, somehow, not yet in relation to Muslims. So, but it is, there's a lot there that can be used. Similarly, the supervisory practice emphasizes the importance of an inclusive curriculum, promoting respect for religious diversity. But again, so far, this hasn't been teased out in relation to Islamophobia. To counter Islamophobia in societies, whereas it's, as we started off with at the beginning, it is obviously a growing problem. So again, there's a lot more that can be done. Next slide. Well, maybe what I should have said before going to this slide, but that's okay, you don't have to go back, is that, so there are overall, if you look at the Framework Convention, there's a lot of potential, both in terms of, textual provisions as jurisprudential lines, but it can also, there's a lot more that needs to be done in terms of consistent application. So now comparing the fault lines of the jurisprudence, looking at two levels. On the one hand, countering acts of intolerance as state duties, and on the other, the active promotion of tolerance. And that would be the two routes along which I could compare the quasi-jurisprudence. Looking at the first leg, the countering acts of intolerance, there's a very mixed picture that emerges. In regard to the equality right provision in the Framework Convention for the Protection of National Minorities, several opportunities have been missed so far to emphasize what should be done to counter Islamophobia. When you look at Human Rights Committee, the complaints procedures there provide very strong protection against Islamophobia. So it's very promising. The ECtHR, there we have noticed that there's been a flawed response to latent discrimination. So it's a very mixed bag in that respect. Going to the other one, yes, active promotion of tolerance. That is obviously something that is most explicitly developed in relation to minority-specific rights. And there we see that it hasn't been consistently developed in relation to Islamophobia, even within the Framework Convention, as regard the provision of education as well. But also in terms of general human rights, there is the possibility to what we call systemic interpretation, when you would interpret the fundamental rights that are there in light of the overarching principle of the need for effective protection of fundamental rights. Also there, more could be done to read in duty, positive duties to counter to actually promote tolerance between the groups and thus counter intolerance, right, via the active promotion. Bringing me to my last slide with some overall recommendations, again, alongside the two pillars that I distinguished. Regarding complaints about acts of intolerance, the argument would be then when there is a signal of an Islamophobic context, it would be important to employ strict scrutiny in relation to the freedom of religion. And there should be an explicit non-discrimination analysis, like acknowledging that there's a suspect clause involved, whereas there should be a more critical attitude about hidden direct discrimination. Regarding the active promotion of tolerance, as I already said, in terms of general human rights, way more can be done to develop identifying duties, active duties to promote tolerance, demands of inclusive education, and awareness raising, duties to have awareness raising campaigns about Islam. And in terms of the minority-specific rights, oops, that was one sentence too far. Also here more is awareness needs to be garnered in relation to Islamophobia. So that on that note, I would like to end my presentation. Actually, not 100%. So basically, no, it's okay. It's fine. It's good. I'm good. Yeah. I thought I wanted to say something more, but I think it can come, it'll be better if it comes to questions. So it's all good.
Okay, many thanks. Thank you, Kristin, for your thought-provoking presentation, which had so many dimensions to it. You really set out very clearly the relevant case law across 3 international bodies. I was quite interested in your intersectional analysis of Islamophobia, particularly the intersection with gender. I have a couple of broad questions, a couple of general questions for you that are in the area of. So I would like to wrap up proceedings now to thank everyone for attending the talk today, and thanks to Ahmed as well for his his comments and questions, and to everyone for their questions. I would like to take the opportunity, oh, there's another poll just popping up there, to thank Matt for his technical support and to Katja for managing the slideshow. But mostly I would like to take the opportunity to thank Kristin for taking the time today to deliver an excellent presentation to our human rights community. We really appreciate your contribution here today.
Can I say something still?
Sure.
I also would love to thank you, because it's also, extra, you need to make extra time to listen to another professor speaking for a long time. And I actually value all your questions and comments, and I haven't been able to look everything up, but I'm grateful that they're going to send to me. So also thank you to Ahmed, brilliant questions. Maybe we should look together at E versus Austria, see what we can make of that. So no, absolutely. I really enjoy this opportunity because for me, I think work is always a work in progress. So I'm going to definitely look at all your comments and questions, and I'm sure that's going to give me lots of interesting ideas to further develop. Thank you very much for that.
Thank you.